Welcome to our California Real Estate Exam Prep video series. We'll give you 20 daily practice questions for the next 100 days with detailed answers to help you pass the exam and get your license. If you like our videos, please like and subscribe. Let's start now.
1. Which of the following indicators would best define the purchasing power of the US dollar? A. Discount rate. B. Gold standards. C. Interest rates on Treasury notes. D. Price indexes. Answer: D. The Consumer Price Index indicates the purchasing power of the US dollar in relation to a set list of goods and services. 2. The legal meaning of the word waiver as it is applied to real estate transactions most nearly means: A. Estoppel. B. The justifiable reliance by one party upon the intentional act or omission of another. C. A unilateral act and its legal consequences. D. Detrimental reliance. Answer: C. The word waiver, as applied to a real estate transaction, most nearly means a unilateral act and its legal consequences. One party waives certain rights. 3. The fact that no two parcels of land are exactly alike is one of the bases for courts of law to enforce: A. Lease pendens. B. Decrees of partition. C. Specific performance. D. Quiet title action. Answer: C. The fact that no two parcels of land are exactly alike, i.e., non-substitutable, is the primary basis for a court of law to enforce the legal doctrine of specific performance. 4. The disclosure statement which is required under the Truth in Lending Act would include: A. A list of the items that are included in the finance charge. B. A description of the security interest held by the lender. C. The annual percentage rate. D. All of the above. Answer: D. The law provides for inclusion of statements A, B, and C, hence, item D is correct. 5. A homeowner failed to make payments on his trust deed loan for 2 successive months, and a notice of default has been recorded. He has: A. Rights of redemption. B. Rights of reinstatement. C. Loan moratorium rights. D. Lost his opportunity to stop foreclosure. Answer: B. A borrower under a trust deed has 3 months from the recordation of the notice of default to reinstate the loan by making up back payments plus any late charges, penalties, etc. 6. When could a broker refuse to present an offer to his principal? A. The seller has accepted an offer and a backup offer. B. The broker is working as a gratuitous agent for the principal. C. The second offer is significantly lower than the first offer. D. The seller has expressly told the broker to not submit any further offers. Answer: D. Only when the seller has expressly told the broker not to submit any further offers is the broker relieved of his responsibility to present all offers. 7. A subdivision is encumbered by a blanket encumbrance. As each of these encumbered lots are sold, the beneficiary should issue which of the following? A. A partial deed. B. A quitclaim deed to the new owner. C. A request for a partial reconveyance deed. D. A request for a variance. Answer: C. As each parcel is sold, the effect of the blanket encumbrance would be removed by the issuance and recording of a partial reconveyance. 8. A trust deed loan may be foreclosed by which of the following? A. Court action only. B. Trustee sale only. C. By the mortgagor. D. By either trustee sale or judicial procedure. Answer: D. A trust deed may be foreclosed by either a trustee's sale or a court suit. 9. In the event a person is discriminated against in violation of Title 8 of the Civil Rights Act of 1968, that person may seek relief by A. Filing a civil action in a state court. B. Filing a complaint with the Secretary of HUD. C. Filing a civil action in a federal court. D. Any of the above. Answer: D. Such are the rights of a person under the 1968 Act. 10. The Real Estate Bureau investigators have determined the broker has been misusing trust funds. Under these circumstances: A. The broker's license will be immediately revoked. B. The broker's license will be suspended as soon as formal charges are made. C. No action can be taken by the commissioner without a formal hearing. D. None of the above. Answer: C. The commissioner can act to revoke or suspend the license only after a formal hearing. 11. Buyer Smith agrees to take over the existing fire insurance policy presently in effect on the property in the name of the seller, Mr. Wilson. When will Smith be protected by this policy? A. Immediately upon notifying the insurer of the name change. B. Upon receiving possession of the property. C. At close of escrow. D. When the insurer approves the assignment. Answer: D. The insurer has the right to approve or disapprove any assignment of the fire insurance policy. Coverage does not become effective until that assignment is approved by the insurer. 12. An act of the promisee from which the promisor derives a benefit or an advantage would be a definition of A. An unenforceable contract. B. Negative fraud. C. Subrogation. D. Consideration. Answer: D. Consideration is something of value exchanged in a contract between two parties. It is the act or promise of one party that is given in exchange for the act or promise of the other party. 13. At the time of purchasing his home, the buyer gave the seller a note that was secured by a mortgage. Concerning that note: A. It hypothecates the property. B. It is evidence of the debt. C. It is merely a pledge. D. All of the above are true. Answer B. The note is the evidence of the debt. The other document, mortgage or trust deed, would secure the payment of the debt. 14. The primary intent of the Federal Equal Credit Opportunity Act is to A. Limit the maximum size of loan a lender can make and thus make credit more available. B. Regulate the minimum requirements for qualifying for a loan. C. Eliminate discrimination based upon sex or marital status in the granting of credit. D. All of the above. Answer C. This law intends to make credit equally available to all persons without regard to sex or marital status. 15. An order or a decree by a court prohibiting an act by an owner of real property is A. An injunction. B. An indenture. C. A writ of judgment. D. A mandatory. Answer A. An injunction is an order or a decree by a court prohibiting an act by an owner of real property. 16. In the event a real estate broker finds it necessary to discharge a real estate salesperson employee for a violation of the provisions of real estate law, the employer must notify the real estate commissioner. A. It is not the responsibility of the broker to inform the commissioner. B. By certified mail within 5 days. C. Immediately, together with a certified statement of facts. D. Within 3 days of the termination of the licensee. Answer C. The employer, broker, must notify the commissioner immediately with a certified statement of facts. 17. If a real estate investor wants to use the principle of leverage, he would A. Invest in real properties where values are declining. B. Use borrowed money to the maximum extent possible. C. Use borrowed money and personal money on an equal basis. D. Use his personal money as much as possible. Answer B. An investor who uses leverage borrows all of the money that he can and invests as little of his own money as possible. 18. Most lending institutions making loans where real estate is the security would offer the lowest loan-to-value ratio on which of the following properties? A. Industrial. B. Residential. C. Commercial. D. Vacant land. Answer D. The least LTV is vacant land since vacant land has no income. 19. The following answers in regard to metes and bounds are all correct, except A. Metes and bounds is a good method when there is not a map recorded of the property. B. A major advantage of metes and bounds is its brevity, simplicity, and uniform interpretation. C. Metes and bounds descriptions are perfectly legal. D. A term used in describing the boundary lines, together with their terminal points and angles. Answer B. Metes and bounds is a long cumbersome description used to outline a peculiarly shaped parcel of land. 20. Mr. Abel is building an addition on his residence that does not conform with the existing deed restrictions for the subdivision. If an owner in that subdivision wishes to stop him from proceeding, he should obtain A. A desist and refrain order. B. A lease pendens. C. A court judgment. D. An injunction. Answer: D. An injunction is a court order to stop a present action. A desist and refrain is an order to prohibit the commencement of a certain action. A lease pendens is a notice of lawsuit, and a court judgment is an order of any type issued by the court.
Thank you for watching. I hope you found this video helpful. If you did, please consider subscribing to our channel so you don't miss out on our future videos. I look forward to seeing you in the next one.